Just a copy.
See, only request is kindly try to finish it off today.
Yeah, I'll try and finish.
Please.
I will, definitely. So, Manoj, may I just go rapidly while the thing is to be handed over?
Yes.
I am now generally going to move into the tariff area, but I want to just summarize for 5 minutes the arbitration and then make my submissions with reference to the Arbitration Act. So, your lordships have seen that the arbitral award was a reasoned and a speaking award, number one. Number two, issues were framed by consent of the parties. You recall that. Issues were framed by consent of the parties. There was no issue at that time on limitation, though limitation has been dealt with. Third feature, very, very important. All the correspondence which was exhibited, etc., or placed before the arbitrator was examined. He has looked into those correspondences and come to the conclusion that, look, there were negotiations, talks, etc., which were going on all the way until 1998. In fact, there was correspondence by the chairman of the Port Trust as well, which says that, yes, we can certainly consider, we can revise, etc., etc. So there were discussions, there were interministerial talks, and there were actual correspondence between the parties and meetings as reflected through that correspondence. So that's a very important factor from keeping in view the issue that, look, there was always this whole business which was back and forth, which was going back, and eventually it was only when they said, I won't allow your ship to or vessel to berth in the port, that I was constrained to file that suit, which eventually led to the arbitration. Your lordships will recall that. The other points which I want to mention at this stage, my lords, is that apart from all of this general, the court looked into the reasons which they justified or they put forth for the purposes of enhancement. There were three reasons. The first reason was wage increase in 1989. This is what they put forth. So the court examined those reasons. The court said, sorry, you had a scale of rates increase in 89, so I'm not looking at a wage board increase in 89 to justify a 1993 enhancement. One. Two, they had a wage board. The second point they said, I am entitled to an enhancement is because of a wage board increase in 1994. To which the arbitrator came up with a completely plausible view in our respectful submission, saying, you can't have a 1993 increase in scale of rates and justify it on the basis of a wage board increase in 1994. And the
wage board had not given from a back date.
No, the wage board had three things. 89. I'm going by the award, Manoj. The award says
any date is given because sometimes the board is
no,
from a back date it is given. That's
no. At least from I couldn't find that in the award. The award says that, look, there's a 1994 a wage board increase, but in any case, Manoj, 93, assuming the wage board retrospectively made it from earlier, in 93 you didn't know that a 94 wage board is going to come.
all right.
So simple. So 94 wage board can't be used. And the third reason they put forth was OSWAL. And they said that, look, as far as OSWAL is concerned, those rates are higher and better, so compare it to OSWAL. To which the arbitrator said that, look, OSWAL is on 27th August 1999. So you can't use a 27th August 1999 negotiated rate to justify something which has happened in 1993, apart from the fact that in 1985 itself, the Maya agreement was entered into in 1980. Finally, my lords, I want to just mention before we go into the statutory provisions on arbitration, it's a very clearly written and precisely written and concisely written award. That's my respectful submission. What a court reviewing under 34 or whichever the section is, it seems, did you apply your mind? Did you place the issues? Is there some reasoning which is plausible or not? If all of that is there, then according to us, there is a vanishingly thin area for jurisdiction or justification for interference by a superior authority. So please keep that in mind. Of course, I've already mentioned that it was scrutinized at a one appellate level and at the High Court level, and then it has passed muster. Now take up the Arbitration Act, section 34, please. 34. Now, one point I should mention, which was not mentioned, my learned friend mentioned it in passing, but you may just note it. There is an order passed by this court, please just note the date, on 12th January 2016. Our court's order. Would you like to look at it, Manoj, because it's inter partes. I don't think it may not have been pointed out, but I'll just point it out.
There in the paper book?
Yes, it's there in the paper. So please go directly to Manoj. It's in the counter affidavit of the first SLP at page 88 or PDF page 93. Page 88. just have a note. My learned friend did refer to it, but
Page 88 is.
yes. So this is the same party, same proceeding, my lords. It had come up earlier. Your lordship has it, page 88, order dated
Yes.
12 January 2016.
Yes.
Okay. So can I just summarize it and tell your lordship what it said? The court felt that in the facts and circumstances of this case, the writ petition becomes the appropriate forum for adjudicating all these complaints against the award. Normally, your lordship knows it is 34, but now overall they looked at it. That is what this order said. Would you like me to place it or not necessarily?
No, not at all. We take it, no problem.
Yes, it's just so that you have the page before you. Because there was an issue regarding execution, this, that, and the other. So the court said in the writ jurisdiction, our court said in the writ jurisdiction, you decide whether the validity of the. But that doesn't mean, in my respectful submission, that the parameters under section 34 are to be ignored. You would apply those same parameters. That is why I'm taking you to 34. Now, please see the narrow section provisions. Please just see. Recourse to a court against an arbitral award may be.
So that we noted it down, no problem.
Now look at the
That,
subsection.
the 34 interference is very restrictive, therefore it same thing will have to apply to writ petition. We got it.
Right. But the second point which I'm making, I'm obliged. The second point I'm making is, please look at subsection 2 and glance over the headings. Not one of them is even remotely applicable under A or indeed B.
That's correct.
What the arguments which were advanced, because eventually what was the argument? The argument was that, look, there is a overriding statutory power that I have to fix the rates under 19 and therefore ignore the settled position under 1. So this was, broadly what was contained. This would not, a plausible view has come up, it would not fall under any of the technical points under subsection 2A of 34, nor would it come under B. The subject matter of the dispute is not capable of settlement by arbitration. That has no application. The arbitral award is in conflict with the public policy in India. And then your lordship sees the explanation. For avoidance of doubt, it is clarified that an award is in conflict with the public policy only in India only if the making of the award was induced or affected by fraud, corruption, or was in violation of 75 or 81. It's in contravention of fundamental policy of Indian law, or it's in conflict with the most basic notions of morality of justice. This does not apply in my respect to any of the grounds canvassed. I would respectfully urge your lordships not to therefore interfere in this well-reasoned award in what is essentially a commercial dispute between the parties. Now, my lords, I will do my judgments later on. May I now come to tariff? So I am completed except for my judgments and citations. But none of these grounds apply. If these grounds don't apply, then of course the scope for interference is not there at all. Now, my lords, may I come to the issue regarding tariff? Now, please note two things. First, we are concerned now with the period. I'll just give you the period. For tariff, we are concerned with the period 1st April 99 till 31/3/2010. So please note that. 1st April 99 till 31/3/2010.
Yes.
Thereafter, there is no dispute. Or
Thereafter, my lords, it's not before your lords.
otherwise.
Yeah, there is some contention that they'll keep, my lord, whatever they want to do, they will keep the parties.
No litigation is there.
So there may be some litigation. I'm told there's some writ petition and this and that. But but for our purposes, let us focus on this video. Now, this has to be divided into two parts, so you may note those parts. 1st April 99 till 27 December 2002, being the date of the award, is the period for which tariff was determined by TAMP pursuant to the arbitrator's directions, which both parties followed. Okay, so that is 1st April 99 to 27/12/2002. 27/12/2002 till 21/3/2010. It's 31. I'm sorry, it should be 31. My mistake, Manoj. It is 31st March 2010. Is in terms of an order, please note, dated 8th July 2009. Which was passed by the High Court of Orissa. So there were disputes between the parties. It eventually went to the High Court there. High Court said TAMP to decide. All right. So now you know how this
At
particular.
that time, law also had come.
Yes, TAMP was there. The tariff authority, your lordship is correct, was instituted in 1997.
Seventh Amendment is there.
Yes. And it was with effect from 99. So that is how the arbitrator put it there. For the period, I gave your lordships that 1st April 99 to 27 December 2002. That was the arbitrators himself saying so. Go there. And Orissa High Court separate proceedings, not to do with arbitration. sent it back to TAMP for this period. So the TAMP order comprises both these elements. So your lordships have now seen that. Now the second element which I just want to mention now in respect of TAMP is, please note, there are 2-3 things which I just want to indicate. Now for this, please just have a look at, I'll just hand over a set of compilation of these TAMP, the tariff order. So just note these tariff order statutory notifications which have been issued. Give it to them. My learned friend has correctly pointed out 2005. You remember those guidelines. So I'll come to that in a moment. But just see what has happened. Just a couple of things here subsequently. So the first is a TAMP in the index you will see is the 27 January 2015 TAMP policy for determination of tariff. Because your lordships had these questions for us, you remember. How is it done every 3 years? What is it? Correct? You remember that. So that's why I have placed this on record. Now, on page 1, 27 January 2015, 10th line, above preamble, policy for determination of tariff for major ports 2015. Your lordship may just mark that. Yes. Now, then just go to 1.3. I'm only going to point out 2 or 3 things. 1.3, the policy itself shall come into force unless reviewed, it shall or extended by the government, it will remain in force for 3 years. So that is what they felt. Then please go directly to 2.10. 2.10. Tariff agreement for captive berths facility. This doesn't apply to us. Well, this is subsequent. This is 2015, but I'll place it before you. Tariff agreement for captive berths and facilities where a separate tariff arrangement is prescribed in the mutual agreement entered into between the port and the concerned user will continue to be governed by the respective agreement. Tariff for captive berths and facilities not covered by specific agreements will continue to be stipulated by TAMP. So I'm emphasizing this because what the arbitrator did in 2002 is exactly what TAMP does. Look, if you have an agreement, sanctity of contracts, by and large, we'll go by that agreement. By and large, they always make some adjustments as they have in my case as well. But by and large, the policy of the law is that if ports, because there are massive investments are coming into the country. So therefore, we, TAMP, if you have negotiated the agreement, will broadly support it. Now just go overleaf. This is, Manoj, again answering the court's question. Clause 5 is procedure for filing and processing of proposals. All right. So there are proposals which come up before them. And then, for example, you will see in 5.4, so if there are no objections, it goes through, etc. I say they don't even need to organize a hearing in 5.4. You will find that. And then, of course, if there is some grievance redressal, you can go back to TAMP, etc. So this is one. Then please see Tariff Authority. Now, pursuant to this policy, they have issued a notification of working guidelines at page 5. Page 5, working guidelines, 4th June. And here, just see only 2 clauses, 2.13 on page 8. Now, this is all India. This is not just for this Paradip. All India. How is it? How do they go about all India? 2.13. As per clause 2.10 of the tariff policy, in case there's a separate tariff arrangement for a captive berth or facilities by way of mutual agreement entered into by a port or concerned user, it will continue to be governed by the respective agreement. The concerned major port shall approach TAMP for notification of such mutually agreed rate. Tariff for captive berths and facilities not covered by specific agreements will continue to be stipulated by TAMP. So this is all India. Yes. Look at 2.13. This applies across the country. This is not some one person who's being victimized, etc. You can't therefore use your general power to fix scale of rates under Major Ports Act because TAMP as a national policy says, sorry, this is my guideline. If you have an agreement, it's the agreement. But of course, they can always make small repairs, if there's some difficulty, etc. 3.4. In case there are no objections, that I have placed. Now, please just proceed further. You just note the clauses. There's another notification in 2019, which is at page 24. 24. And at 25, 2.10, you will find similar clause, 2.10. It's more or less in the same terms.
Yes.
2.10 at page 25, agreement is paramount, and guidelines which are at page 28, you will find a similar clause, 2.13 at page 31. Page 31.
These are again the guidelines only.
No, so subsequent, no, Your Lordship, recall these.
These are tariff policy for major trust.
This is across the country. So this is, you remember 2015, then the next line came in 2019. Same policy is continuing, my Lord.
It is revised.
Yes, it is revised, but this has remained the same. Correct?
This doesn't mention that this is within 2015 notification.
No, it does. Sorry, please just see, please see now the 29.
In compliance.
Yes, just have a look at page 24. Page 24.
Yes.
Your Lordship has page 24, 16 January 2019. Now, this is the tariff policy now introduced in 2019. So, the earlier one, 2015.
No, this doesn't mention that 4th June 15.
Yes, yes, it does. You will see that, for example, just have a look at the taking into consideration, the second para in the preamble. Taking into consideration comments, suggestions of major ports during the consultation process, the policy determination under the 2015 issued by the Ministry of Shipping dated 13 January has been modified. The 13 January 2015 has been modified.
We have seen two notifications, 27th January and 4th June.
Yes.
They are not referring to the...
Next line. In supersession of policy for determination of tariff 2015 issued by the Government of India and Ministry of Shipping Communications of 13 January 2015.
We have the notification of 27th January, not 13th January.
There's something on 27th, my lords, which I placed first, 2015, page 1.
Yes, that is 27th. And page 5 is 4th June. Both are not referred here. This may be some independent...
No, just see, on if you go to page 1,
Yes.
just go to page 1.
Yes.
They've taken some other date, just see this. Second paragraph on page 1. The relevant clause of major port called policy for determination of major ports will come into effect from the date of issue. The Ministry of Shipping has issued these directions with a letter of 13 January 2015. Your Lordship has that.
Yes.
13 January. Accordingly, so and so will come into effect from 13 January 2015. I think that's where they get the 13th January 2015 date. So this you have seen now, page 24. Same clause is at 2.10 is page 25. Same guideline or similar guideline is 2.13 at page 31. Page 31, 2.13. Your Lordships have it. And now, and just to complete page 47, is the Government of India Ministry of Ports and Shipping. Now they have a tariff policy of 3rd November 2021. And here, you may go again to 2.10.
Earlier was notification, this is only letter.
This is a communication, my lords, to all major ports.
Earlier what you have shown was the notification.
Yes,
This is simply a letter
yes.
referring to...
This, your Lordship, will see is by the government because there's that new act, my lords, which has come in. The new act. You remember, I'll take you to those provisions. Here, TAMP is continuing. Now look at 2.10, please, page 50. Tariff arrangement for captive berths facilities where a separate tariff arrangement is prescribed in the mutual agreement entered into between a port and concerned user will continue to be governed by the respective agreement in the event a captive berth is awarded in future by major port authority following the tendering process. It will be governed by the proviso under 27(1) of the Major Port Authorities Act 2021. So that's the new 2021 Act. Yeah. So, my lords, my respectful submission is that the arbitrator has actually anticipated what the all India national policy is for all these years and which continues, which nobody has challenged. Which is, if you have an agreement, then that agreement governs. You can't go into some general scale of rates and this and that and the other to override that. Now, this is therefore by way of background. Now, please have a look. I'll come to the statutory part later because that's a little, or maybe I can complete it now. Please just have a look if your Lordship sees. There is, my learned friend actually made a reference to it all as well. Just see the new act, my lords, the new Major Ports Act, if you want to just see. There's two provisions here. It doesn't affect us, but your Lordship are also concerned about the way forward. The way forward.
63 Act, 21?
No, please, the 21 Act. Yeah. The Lordship has the 21 Act.
Yes.
So there are two sections here I'm inviting attention to. They are 54 and 58. Yeah. The Lordships was also mentioning, I think, when my learned friend was arguing that we are concentrating so many appeals to the Supreme Court. Now here also there is an appeal to the Supreme Court. So 54 contemplates constitution of an adjudicatory board. Your Lordship has that?
Yes.
Section 54 of the 21 Act. Your Lordship has that,
Yes.
correct? Then the proviso provided that until the constitution of the adjudicated board, the tariff authority of major ports under 47A shall discharge functions. You get it? The proviso. So TAMP is continuing. I'm instructed even today, but that is because of this proviso.
Board is not there.
Yes. And then just have a look, if your Lordships would, at 58.
Yes.
Powers and functions of the adjudicatory board. Receive and adjudicate references and disputes or differences claiming relating to rights and obligations of major ports and public-private concessionaires, captive users for dedicated berth, etc., etc. Correct? So there is a machinery. That's what I'm trying to say. If there's a genuine dispute, people can definitely go there for the purposes of resolution. That should not bother us. But there is a power to the Supreme Court, your Lordship will find under Section 62. Of course, we'll keep quiet on this, at least for the present.
Because board is not there, TAMP is continuing. So,
Yeah,
any
so
appeal
far.
from TAMP's order will also come here?
I don't know. We'll leave that conundrum for another day. But if your Lordship is just having a look at 58,
Yes.
if you see this is now parliamentary statute 58 1B. To receive and adjudicate references of any dispute or difference or claims or relating to rights and obligations of major ports and public-private partnership concessionaires or captive users for dedicated berth within the framework of their concession agreements and to pass orders after considering the hearing all parties involved in the dispute. So, I mean, that agreement is now being elevated, Manoj, because it's a negotiated agreement.
But still, if there is
But there
no
is a-
agreement, then the power is there.
No, of course, Manoj, because you must have a dispute resolution machinery, Manoj.
Yes, yes.
This is it. All I'm pointing out is that this is your.
You say, they say 100 rupees, you say 50 rupees, so somebody has to adjudicate.
Someone agrees. If you don't agree, someone may have to justify the increase, etc. If
Yes.
a relation is within that framework.
Yes.
So, Manoj, now this is important from our purposes. Now, just have a look, if your Lordships would, to that my learned friend had referred to the 2005 TAMP notification. So you will find that at page 172 of SLP 9870 of 2023. This is now what was governing. You remember, I just brought this because your Lordship were keen to know what is the way forward, etc.
Which?
172 SLP 9870. I believe it should. Your Lordship has it. My learned friend referred to this.
Yes, yes.
Now you have this at 31st March 2005, correct?
Yes, yes.
Yeah. Now just note 2-3 things. So this is issued by the Tariff Authority for major ports. And please have a look first and foremost at 3.2.5.
3.2.5.
Then I'll go back.
No. 3 has only 2.
I don't know, some.
2.5.
I have again, you're right.
No, it's there. Page 175.
I don't know how it's there, but it is there. I don't know if there's some typing error,
Some error maybe.
maybe some numbering error.
Numbering error because 3.2, then 3.1.3 it starts next page. Then 3.2.
Maybe we'll try and check.
Or I think has come here maybe. Yes, 3.2.5.
So just so that you have the backdrop as to how they operate and function in terms of procedure, as part of the consultative process, now mark the next few words, if necessary, hearings of a case or proposal will be organized jointly with the port and users of the port, either at the office of the authority or at the port. Now this is very important for my purposes. Because these are the guidelines under which they operate all India. And it's, if they find it, if necessary, you have to provide for a hearing. Now, nobody's challenged this. And I am going to show you, of course, a hearing was granted and all, no difficulty on that. That I will show you. They were heard, they were present. But just even, it can't be, oh, no natural justice, no hearing given, whole tariff authority or award just to be set aside. Nothing doing. It's an expert body. It has called for the information. It has, when we go through those orders which were not placed before you, you will find they are so detailed as far as every grievance, every issue. They were asked to submit further material. They were asked to submit material to me so that conjointly whatever is agreed upon can be agreed upon, and then it all goes before them and then they fix and they take it. So this is important in terms of proceeding. So 3.2.5 is part of this processing of approval. Just go back to get a flavor of it. Top of page 173. 3.1.3. Major port trusts, including private terminal operators at such ports, shall initiate tariff proposal and forward the same to TAMP at least 3 months in advance. 3.1.4. The port trust may send the proposals with the approval of the board of trustees of the port. The view of the board of trustees will be considered, provided they were received within 2 months from the submission of the proposal. 3.1.5. TAMP will not entertain representations filed by individual users unless it involves the fixation of tariff and scale of rates. All tariffs of ports, etc. will be and then. So just to tell, because your lordship's question was, now how does this authority function? So this is the 2005 guidelines which they were following. They termed this as, notification and a preamble in exercise of their decisions, policy powers, etc. So this is how they were operating. Now please just go. Yes, so sorry.
There seems to be some error in this notification.
Yeah, I think the numbering for sure.
Not numbering only.
Okay.
If these are the guidelines only, then this 4-part business will not come. They say the various organization consulted, subsequent consultation.
Which is your paragraph?
172. Just bottom, this table is there. This looks like that some consultation was there and some order was passed. These paragraphs show that. But other paragraphs you share, those are the guidelines only.
No, this is part of a similar. I think the numbering being off, we will just check up this 2000. We'll just check up whether it's a few pages.
The website because.
Yeah, we will try and give that because you must have the correct notification. I just assume this was
that
correct.
is some order of part of some order passed after hearing.
Okay, we'll just check that.
Yes.
Well, I apologize. I'll just check it up.
This is only for the purpose of formulating the guidelines.
That's correct.
The very first paragraph, if your lordship sees at page
But
170,
just see the bottom.
the bottom, yes, my lord, because all these
various organizations consulted.
yes, these are ports actually. Chennai,
Guidelines, these were consulted.
they were consulted for the purpose of framing guidelines.
Really?
All right. Yes. Maybe.
Yes, my lord, because on preamble paragraph, your lordship will find organized a national level workshop in February at Chennai to deliberate concept, principles, approaches, and modalities.
Of their relation.
Yes,
Very
and
good.
then, my lord, list of organizations consulted, that is, my lord, all these are port trusts. My lord.
Yes.
The heading there is of the first column is port.
Maybe for that. Yes. But numbering maybe there's error. All right.
Numbering is a fault.
Yes.
There's some problem.
Maybe.
Okay.
These-
Consultation is not for
These
guidelines.
voters are the mere schedule. Following schedule and venue. Okay.
So we must place the correct.
Go to.
We'll just check it up on.
Okay, it's wider consultation they made.
Looks like-
You're right, but only for the purpose of framing the regulation, that's all.
My lord, there is a possibility that some page between 172 and 173 has got left out.
But
I
we'll-
will
I
check
think-
that up.
No, that's fine. Anyway, that may not be that much relevant.
Okay. Now, my lords, let me just state the point. Your lordship may note it, then I'll take you to the two documents. In our case, there is an interim order, tariff order, passed by TAMP. Please note the date, 29/11/2010. There is a final order dated 22/11/2011. And the third date, which your lordship may note in light of the submission made by the other side, is that they were granted a hearing on 9th December 2009. 9th December 2009. So your lordship, now please go,
By temp.
sorry,
By temp.
by TAMP. Now please go to the interim order at which you will find at page 217 of SLP 9870. 217. Your lordship has 217?
Yes.
does it below order mention the date, 29th day of November 2010?
29 December, November 2010.
Your Lordship has that, correct?
Yes.
Now just see the first para. The Paradeep Port Trust has entered into an agreement August 85 with Paradeep Phosphates. Your Lordship has that? So now this is because of the reference, then I'm with your permission skipping the various recitals, history, etc. Please go to page 219. .1 do you have?
Yes.
Under letter of 13 July 2009, Paradeep Port Trust submitted a copy of the High Court order dated 8 July 2009 and requested to revise and equate the rate of the captive berth of PPL to that of IFCO with a minimum guaranteed throughput with effect from 1st March 2002. So they themselves are doing it. Jurisdiction, this, that, they are themselves coming up with this particular proposal which eventually came through the High Court and was referred to. So that's the proposal. They want the equation to IFCO. All right. Then this you will just see the detailed consideration, materials, documents, etc. looked at. And then you may go, please just peruse these pages since your lordships have them before you. And then there's a whole detailed tabulated statement which goes on till page 239. Where there's an analysis of what PPT is claiming, what the agreement says, etc., etc. Go all the way up till 239.
According to you, everything which they pointed out was considered.
Now see, para 9, para 8, I don't know how can they make a submission about natural justice. Just look at this, para 8. A joint hearing in this case was held on 9 December 2009. The Port Trust made a PowerPoint presentation of its proposal. The Paradeep Port Trust and the Paradeep Phosphates Limited made their submissions. The gist of the joint hearing is as under. So, look, it was to be given only if necessary. It was given. They made a PowerPoint. It is a highly technical matter, my lords. This is not some dispute on highly technical matter. Your officers come there, A comes there, B comes there, PowerPoint. Then they summarize PPT. We have looked into the figures for the first year, each of the 3-year tariff block, etc., etc. Their submissions are summarized. Then my submissions are summarized. We also have agreed with certain, we agree that PPL, page 240, we agree that TAM should adjudicate upon the tariff payable from April 99, etc. We are unable to furnish, etc. Now 9.1, as agreed, now, sorry. So, my respectful submission is, this is not the trapping of a court, it's a tariff authority with all those experts. Now just see what they record in 9.1 at page 240. 240. As agreed at the joint hearing, PPL was requested to furnish the design capacity of the cargo handling facility of the fertilizer berth number so-and-so, and also to submit its audited accounts for the last 3 years. Under letter dated so-and-so, PPL furnished its audited accounts and the balance sheets for the years 6, 7, 7, 8, 8, 9. It also furnished the design capacity of the cargo handling facilities of FP1 as under. Now that is further given, details are given. Then please now go to 11.2 or 243. PPT, that's the Port Trust, also submitted cost statements. Then they give that cost statements 98, 99 to 2008, 2009. Now please see last 2 lines on that page. Last 2 lines on 243. Absence of mutual consent is one of the primary reasons for the controversy traversing through the arbitrators and various litigations before reaching the authority for fixing the rates in view of the directions issued by the High Court. Generally, this authority prescribes ceiling rates in the scale of rates of a port authority for provision of different services and use of various facilities of the port. The authority ordinarily does not take up any individual case arising from bilateral agreements for fixing separate rates unless exceptional situation is made out in the instance case. The arbitrator in his award pronounced on December 2002 ruled that TAMP has to revise the rates with effect from 1st April 99. The Honorable High Court of Orissa has also directed the authority to adjudicate the matter relating to tariff fixation for captive berth of PPL. It's noteworthy that both the parties have agreed that the tariff should be fixed for the captive berth with effect from 1st April 99. The authority has fixed tariff for some of the exclusive berths of New Mangalore Port Trust, Kudremukh, Mangalore Refinery Petrochemicals. In both the cases, the relevant agreements between the port and the concerned parties contain a broad methodology which should be followed. The agreement between PPT and PPL is completely silent on this aspect. When specially asked at the joint hearing, both the parties confirmed that they did not know the different cost elements that have gone in the initial tariff fixing. Therefore, we do not have the benefit of knowing how the initial tariff was determined. Tariff guidelines of 2005 prescribe port-wise cost return approach, etc. Even prior to the announcement of the tariff guidelines of 2005, the same cost approach, etc. was granted. Now, please, Miller, so this is in detail. Now, please go to Roman 4 at, 245 top line. The rates leviable on the IFCO case are not determined by a third party by applying any standard tariff fixing method, but decided amongst the parties by the contract. We cannot compel some party who is not only a stranger to the contract of IFCO, but also entered into a separate contract with PPT to be bound by the former contract. It may also be significant here to point out that the tariff guidelines of 2005 broadly prescribe the principle and approaches to tariff setting, but do not go into the micro level of cost analysis by dictating the method, etc. to be followed. Then please go, I'm just skipping some paras, please go to Roman 8 on page 246. The PPT has proposed a revision in the berth hire charges and wharfage for cargo. PPT has submitted that the entire cargo handling operation at the captive jetty is done by PPL as per the agreement. Hence, there is no direct expense incurred by the port in this regard. The port therefore proposes to recover only the indirect expenses relating to the management, administration, etc. Apart from that, the loss for estate activity and expense on unutilized railway facility are also factored while arriving at the rate. Then there's a whole detailed discussion which goes on, and then your lordship will go directly to, please go to page 256. 256, after all this analysis, billing, this, that and the other. In view of the analysis made above, PPT needs to rework the allocable to the berth, no FBI following a methodology given below. That being so, the rates proposed by PPT in the current proposal for cargo handled by PPL cannot be approved. The PPT is advised to file expeditiously its proposal for fixation of the fixed berth hire charge and wharfage charge for handling cargo berth as operated by PPL from the years 99-2000 onwards to 2009-2010 based on actuals and following the methodology explained above. Before forwarding the proposal to the authority, PPT is advised to allow 15 days time to me to verify these figures. So see how they in a methodical manner went about it. Whole detailed hearing, presentations, then principles laid down. After principles laid down, directions to them, furnish this additional information, but before you do it, give us also 15 days to respond to it. Now, after this, you will find there is a final tariff order, and you will find that after this at page 229. So sorry, my mistake. Yeah. Huh? Oh.
This is the final order.
No, the one I passed was the interim order. The final, sorry.
What you read is the interim.
Interim order, please note the date, interim order of 29th November 2010. Now I go to the final order, which is 22/11/2011. Now, just a moment. This tariff order is at two places. So in that paper, it's I believe at 258. 250. I'm sorry, I've got it in another place, but you have it at 258. Your lordships have tariff order.
Yes.
Passed on 22nd November 2011.
It is there.
Right. So now it has I'll go by paragraph number. So it mentions, my lords, all this, the details, PPT and us are mentioned. Then compliance with the order, etc. Those recitals are there.
Oh, any difference in rate was there or the same rate?
Yeah, so some it went up and down. You will find that.
Some change.
Yeah, the whole detailed analysis again. And there is a difference.
This authority is one-man authority only.
It had, I don't know, 3 people I understand.
But this order, page 256, is
Only
signed
signed by the chairman.
Yeah, it's signed by the chair. Now, please see, again, I'm not reading it, but there's a detailed consideration of various technical factors, and then eventually they fix a rate in para 7. In the result and for the reasons stated above, and based on a collective application of mind, this authority approves the following wharfage charges for cargo handled in FB1 and the monthly fixed berth charges for the vessel's berth,
Para 7, where is it?
270.
Yes.
ମୁଁ ଅଛି ଏଠି
Yes.
You will see that conclusion. In the result, and for the reasons stated above, based on the collective application of mind, the authority approves the following wharfage rates. So, just see, I'm giving you an example. 99, 2000 wharfage charges are indicated and the fixed berth charge, rupees in lakhs per month. Go from 30. Huh? 58.20. So, but just to simplify, because there are complexities, from 30 lakhs, which was, it has gone up to 58.60. Do you have that? Right hand column.
Yes.
But for 99, 2000, your lordship has that?
Yes.
Then for 2000, 2001, 59.58. For 2001, 2002, 47.63. Now they've applied their mind. It's gone up substantially, as your lordships have seen. So they have applied their mind. But this is what a tariff authority is about. These are technical issues of a highly technical nature. There's no substantial question of law here. And once your own 2005 guideline says hearing if necessary, PowerPoint presentation, common joint hearing, principles laid down, then please supply information which we need, share the information, it comes to them, they crunch the numbers and they come out with this where they get substantial relief. So, but I don't think this is a case for warrants interference at all. No, so I'm now done with as far as the facts are concerned. Now I want to quickly go through the judgment so that my learned friend has some time as well to rejoin. Now, may I just take your lordships? I'll state the proposition and then give you the judgment. Now, the first proposition, which is, I think, very important. See the interpretation placed by. You just give it. Give it all together. I'll give them all together. To save time, I'll give you all the judgments at one go. Give them also. Okay. So I'll state the point. Well, just first is the recent judgment of called Subodh Kumar Singh Rathore versus Chief Executive Officer. And the relevant paragraphs are 123 to 129. Correct? And my lords, the discussion is in relation to, under the heading, sanctity of public-private partnership tenders. I'm on the sanctity of contracts, my lords. You please do not adopt an interpretation where parties agree, they fix a rate, and then someone says that, no, I can unilaterally change it because I have some power to fix it. What is the sanctity? Now, the point I had made last time as well, sanctity of contracts is absolutely essential in a growing economy like ours, in an expanding economy like ours. If people are going to make massive investments on port infrastructure, etc., surely they must believe the words plain language. And that is exactly what the arbitrator did, which is a possible view. Now, please see the importance, therefore. Para 123. Before we close this judgment, we must also address one very important aspect as regards the importance of maintaining the sanctity of tenders and public-private procurement process. Public tenders are a cornerstone of government procurement process, ensuring transparency, competition, and fairness in the allocation of public resources. It emanates from the doctrine of public trust, which lays down that all natural resources and public use amenities and structures are intended for benefit of enjoyment of the public. The state is not the absolute owner of resources and rather owns it in trust. A trustee of public resources, the state owes a duty to ensure that the community resources are put to fair and proper use and ensures for the benefit of the public, and two, an obligation to not indulge in any favoritism. The state with whatever free play it has in the joints decides to award a contract, to hold up the matter or to interfere with the same would be accompanied by a careful consideration of the harm to the public interest. Public tenders are designed to provide a level playing field for all potential bidders, fostering the environment where competition thrives and the best value is obtained for public funds. The integrity of this process ensures that public projects and services are delivered efficiently and effectively, benefiting society at large. The principles of transparency and fairness embedded in public tender process also help to prevent corruption and misuse. Then there is a quotation which your lordship will find. The sanctity of public tenders lies in the role of upholding the principles of equal opportunity and fairness. Once a contract has come into existence through a valid tendering process, its termination must adhere strictly to the terms of the contract, with the executive powers to be exercised only in exceptional circumstances by public authorities, and that too in loath. The courts are duty bound to zealously protect the sanctity of any tender and that has been duly conducted and concluded by ensuring that the larger public interest of upholding bindingness of contracts are not sidelined by a capricious and arbitrary exercise of power by the state. It is the duty of courts to interfere in contractual matters that have fallen prey to an arbitrary action of the authorities in the guise of technical faults, policy changes, and public interest, etc. The sanctity of contracts is a fundamental principle that underpins the stability and predictability of legal and commercial relationships. When public authorities enter into contracts, they create legitimate expectations that the state will honor its obligations. Arbitrary or unreasonable terminations undermine these expectations and erode the trust of private players from the public procurement process and tenders. Yes. So Manoj, I am only saying, look, the arbitrator has followed this. So please don't, Manoj, upset it. It's a well settled principle. Now I come to my second point. And that is, Your Lordship has this judgment. Sorry. Yes. So, Your Lordship has a decision called Rashtriya Ispat Nigam Limited. This is 2016-12 SEC 405. Now, before I just read this, let me just give you 4 or 5 dates, which you may just note because I'm not going to cite those judgments. But just note.
This is on limitation.
Yes. Now, just note, can I just give you the dates and the citations if you need to check them? I'm not going to cite it. ONGC, you remember that ONGC regime where if you are two public sector companies, you have to go. So I just note the dates of the orders of the Supreme Court. ONGC 1 was 11th October 91. That's before 93. Just note these dates, please, so that Your Lordship will know what was the prevailing regime at that time. ONGC 1, 11th October 91. ONGC 2 was 7th January 94. 7 January 94. ONGC 3 was 20th July 2007. And eventually, this came to be overturned or given a go-by in Electronic Corporation Constitution Bench dated 11th February 2011. So right from 11th October 91 for 2 decades till 11th February 2011, the regime was what I call the ONGC regime. That you two public sector undertakings, you had to resolve it outside of court. So that was the backdrop now. Now in that backdrop, when we were both public sector, at that time you can't just rush to court. This was the backdrop. Now please see paragraph 5 and 6 of this order in Rashtriya Ispat. We shall now consider the settled law on the subject. This court in a catena of judgments has laid down that the cause of action arises when the real dispute arises, when one party asserts and the other party denies any right. The cause of action in the present case is the claim of the respondent claimant to the determination of the base here for the purpose of escalation and calculation made thereon, and the refusal of the appellant to pay as per the calculations. We find that the view taken by the High Court is correct as to when the real dispute arose between the parties to be adjudicated by the arbitrator and so on. Now, obviously the facts don't apply. But in my case, the arbitrator has looked at it, looked at all the correspondence. Now, if your own chairman writes and says, we'll discuss, we'll renew, we will revisit, all right. Ministries are writing. So the real issue arose in terms of limitation when they said, I'm going to stop the ship. Sorry, you pay or I'm stopping your ship. So this is important on that aspect. Now, Manoj, my next proposition is... oh no, then why are we? Your Lordship will just see that ONGC, I just gave Your Lordship that. 91, this is when it started. Your Lordship, we've just given a photocopy. I'm not reading it. 95 sub 4 SEC page 541. But the date is important, please see. So reported in 95, the date of the order is 11th October 91, which is before our 1993.
This confusion arises when the judgments are cited. Sometimes the old judgments cited, published later on, they say latest judgment.
Your Lordships have that, right?
Yes.
Yeah, you noted the date. That's all. Nothing to be read here. Now, please go to the next authority, which is NTPC versus Deconar. On the proposition, the citation is 2021-19 SEC 694. and the relevant paragraphs are 11 to 13.
This is on which issue?
This is on arbitration possible view. Para 11. Before proceeding, paragraphs, I believe, which are relevant are 11 to 13. I'll just place them. Before proceeding further, it's necessary to take note of the scope of interference by courts in arbitral awards passed under the 1940 Act. The court has consistently held that courts do not sit in appeal over the award passed by an arbitrator in quality manufacturing. At the outset, it is to be noted that the scope of interference by courts in regard to arbitral awards is limited. A court considering an application under 30 and 33 of the old Act does not sit in appeal over the findings and decisions of the arbitrator, nor can it reassess or reappreciate the evidence or examine the sufficiency or otherwise of evidence. The award of the arbitrator is final, and the only grounds on which it can be challenged are those mentioned in 30 and 33. Therefore, on the contentions urged, the only question that arose for consideration before the High Court was whether there was any error apparent on the face of the record and whether the arbitrator misconducted himself or the proceedings. Further, it's also settled proposition that where the arbitrator has taken a possible view, although a different view may be possible on the same evidence, the court would not interfere with the award. This court in Arosan held as follows. Be it noted that by reason of a long catena of cases, it is now a well-settled principle that the reappraisal of evidence by a court is not permissible, and as matters of fact, exercise of power by the court to reappraise the evidence is unknown to proceedings under 30 of the Arbitration Act. Yeah, so that's a well-settled principle. I'm grateful. Now, please go have a look at Hindustan Construction, which is in the context of the present Act, which also commends, the citation is 24 2 SCC 613. The relevant paragraphs are paras 26 and 27. And the standard laid down by our court is least interference to be done. Least interference. If you are satisfied, look, hearing given, consideration. Now please go directly to paragraphs 26 and 27 on page 627. Para 26. The prevailing view about the standard of scrutiny, not judicial review of an award by persons of the disputant's choice, being that of their decision to stand and not interfered with, save as a small area which is established that such a view is premised on patent illegality or their interpretation of the facts or terms is perverse as to qualify for interference. Courts have courts have to necessarily choose the path of least interference except when absolutely necessary. By training, inclination and experience, judges tend to adopt a corrective lens, usually commended by the appellate review. However, the lens is unavailable when exercising jurisdiction under 34 of the Act. Courts cannot, through the process of primary contract interpretation, thus create pathways to the kind of review which is forbidden under 34. So viewed, the division bench's approach of appellate review, twice removed, so to say, under 37, and the conclusions drawn by it resulted in displacing the majority of the tribunal and in many cases the unanimous view of other tribunals and substitution of another view. As long as the view adopted by the majority was plausible, and this court finds no reason to hold otherwise, because conceitedly the work was completed and the finished embankment was made composite, compacted matter comprising both soil and fly ash, such a substitution was impermissible. For a long time, it is settled jurisprudence of the courts in the country that awards which contain reasons, especially when they interpret contractual terms, ought not to be interfered with lightly. The proposition was placed in state of UP versus Allied. So, Your Lordship, I think it's a good summary of the law. Then, Your Lordship will see Reliance Infrastructure is the next decision, 2019, 3 SEC 352. Now, this is on a slightly different subject, albeit in the context of Electricity Act. You may just note the paras 37 to 40. Now, this is tariff fixation and the standard of, what ought there be an interference? What is the standard to be applied in these type of expert bodies? So, look at para 37, please, on page 375. Tariff fixation is a complex exercise involving a careful balance of numerous considerations. There shall be guided prescription under 61 during the appropriate requires the appropriate commission to bear those considerations in mind. Deducing past performance on the basis of historical data, balancing diverse policy objectives, evaluating comparative weight to be ascribed to interests of stakeholders in a scientific exercise which is to be carried out by the Commission. The nature of judicial review that is exercisable in a given subject area depends on, in significant measure, on the nature of the area and the body which is entrusted with the task of framing subordinate legislation. In AP Transco versus Sai, a two-judge bench of this court held thus: fixation of tariff primarily a function to be performed by the statutory authority in furtherance of provisions of the relevant laws. We have noticed that fixation of tariff is a statutory function as specified under the Reform Act of 98, the Electricity Regulatory Commissions Act 98, etc. The functions assigned to regulatory commissions are wide enough to specifically impose these obligations. And then it says, Manoj, in the context of Maharashtra Electricity Regulatory Commission, it's an expert body entrusted with this duty and functions to frame these regulations, etc. And the court, in the context of electricity, said that there is really no warrant insofar as interference.
Yes, yes.
Yes. Now, my lords, the next decision, Madhya Pradesh Industries, is on the part of a hearing. Is an old decision. Does not necessarily mean personal hearing. Now, look, I am just saying, if necessary, but they were heard. They made a PowerPoint presentation. So that's my decision. Now, yes. I'm grateful. So, my lords, the last two decisions, you may just see our court recently in 2025, one SEC 435 in the context of electricity, because that was a statutory jurisdiction, and Mantri Tech Zone 2019-18 SEC 494. So may I just give you the paragraphs? Your Lordship's jurisdiction, we are under 136. We are under 136. In those cases, it was a statutory jurisdiction, appellate jurisdiction conferred on the Supreme Court, confined to substantial questions of law. So I'm really making a two-part argument. Considering the nature of the dispute, even though we have come up from 226, please apply these parameters, which are substantial questions of law. And if nothing is raised, then all right, someone will succeed, someone will get a little more, someone will get a little less. So these words in our respectful submission are, I'm very grateful. Thank you.
Yes.
I'll briefly summarize, Mulad, my submissions in rejoinder, and we'll give a detailed note, Mulad, because the specific points, Mulad, I'll deal. First of all, Milord, as your Lordship knows, there are two parts to this case. One is the arbitration award, the other is tariff fixation by a tribunal. Milord, obviously, Milord, the legal provisions are a little different in the two cases. I have accepted in my submissions, Milord, that when your Lordship looks at an arbitration award, even if it is by way of a writ petition, I have accepted the proposition that the normal process of looking at arbitration awards is what your Lordships will apply. I'm not saying that you should apply some other rule. But, Milord, the very same, Milord, principles is what, Milord, I say has been violated here, and I'll point this out. Number one, we are not saying don't look at the agreement. We are saying that the agreement contains clause 1 and clause 19, give effect to clause 19. That is giving effect to the agreement. Milord,
Your argument.
right. Milord, I'm not going to elaborate, Milord. I'm just going to state and go ahead. Now, next thing is, Milord, the current state of law on arbitration is, Milord, that it should not be contrary to the contract and the award should not be contrary to law. Both of these two, Milord, are substantiated in the language of the agreement, and, Milord, for that I have given your Lordship, Milord, a judgment.
If it is done,
Yes.
on a conjoined reading of clause 119 vis-a-vis section 52,
Yes, yes.
what is the remedy? Is it still open to them to challenge the tariff or not? If it is so,
No, Milord, Milord, I'm on arbitration only now.
no,
Yes.
I'm telling you this.
Yes.
Whichever way you look at it, one issue is whether according to you, this is a wrong understanding of the agreement.
That's
According to them, that's a plausible view.
no, it's not a plausible view. They are not arguing that, Milord. They are saying we are ignoring the contract.
How they ignore the contract?
All right, Milord.
According to them,
Yes.
the contract says it's only by
Agreement.
consultation and by consent.
No, it says this is subject to 19.
Yes,
Section 9, clause 19 overrides, Milord.
Trying to tell their case.
Yes, yes, right.
You understand?
No, your Lordship is right. They are saying that.
Therefore,
Yes.
what we are technically is
Yes.
there are only two issues.
Yes.
One is on the interpretation of the agreement. According to you, clause 1, 19 and 52. According to them, clause 1 will override. 19 is general provision. in which case 52 will not apply.
Correct.
That's right.
That's number.
So, that's right. What we are asking you is that, that's one part.
Yes.
That we will say. The second part is, let us assume you are right.
Yes.
Now, will it not open to them to challenge that decision? Now, when we say it is binding on them, it is not justiciable.
No, they are not challenging the decision of the arbitrator. I am challenging the decision of the arbitrator. Yes.
Let us assume a case where
Yes.
19 is 52 is exercise.
Yes.
What is the remedy of?
All right, my lord. So therefore, your lordship is putting to me, my lord, what happens if there is a dispute relating to that? Now, my lord, the answer is this. As far as the arbitration period is concerned, where there is no other authority, there, my lord, I have given, there is a notification, there is a legal, my lord, delegated legislation which is occupying the field. Now, there, my lord, if somebody has a grievance with that, the only option is to file a writ petition and challenge it on grounds which are available for challenging a delegated legislation.
That's correct.
Yes.
See that.
That has not been done.
No. This case, yes, rightly said there are two periods.
Right.
One covered by the arbitration, another by the tariff authority.
Correct.
Tariff authority, we had statutorily will see whether only
Lord,
issue is
we'll
whether
see.
they have followed the
Yes, my lord.
procedure or not. Any apparent violation.
Yes, my lord. And as I understand your lordship,
Yes.
suppose they had a grievance with the 1993 rates, what was their
But therefore,
possibility?
No, there's a possibility. There must be mechanism.
Yes.
Which is by concern we went by the arbitration.
No. Arbitration cannot, my lord, be overriding, my lord, a notification by the under the law.
You also agreed for arbitration.
No, I agreed. My lord, I agreed, my lord.
Okay.
I agreed that the dispute should be settled. I did not agree that the arbitrator can overrule the law. Because the arbitrator can never overrule the law, and that is the current state of the law.
So says by consent only you can increase.
That's one clause.
Yes.
Yes. The other clause says,
Hey, this will make it very.
yes.
If arbitrator is to decide the application of the clause governing the agreement, no arbitration is required. Directly you can file it to decide any other.
No, my lord. No. Dispute when it arises has to be resolved, even if the answer is obvious.
Yes. Now
Sometimes your lordship
we
is
will go
called upon to decide absolutely
No,
obvious.
we will go to the extreme extent.
Yes.
All right. So let us say it's a case where admittedly clause 19 applies, therefore section 52 applies.
Yes.
Take it. Let us take it.
Yes.
They lose. They have no case at all. Agreement also says so.
Yes.
It is fixed. What then? What is the remedy open to them?
Well, the only remedy open if somebody wishes to challenge a tariff
Waiver writ petition.
is by way of a writ.
Therefore,
Yes.
in this case, writ petition is not there because instead of that, he went by the arbitration.
No, they are not challenging, my lord, the correctness of 1993. That correctness of 1993 cannot be put to an arbitrator. He's a private body. He's a private body. He cannot decide whether the notification by the authority of the central government is right or wrong.
This is not a ground.
But I agree. No, of course it's a ground.
See, that's a problem. See,
Yes.
see, you agreed by the see all the terms of reference. If reference is not there, then
No,
why
my
should you
lord,
have
my lord, there is a very wrong proposition which my learned friend has put forward with great respect. My lord, determining issues in a reference does not amount to estoppel. I am not giving up anything, my lord, but when I say that you can have these issues, your lordship knows the defendant will fix issues, the plaintiff will fix issues, your lordship will say, all right, all these issues are to be decided. Then you can't say that, no, how you agreed to decide that the court can decide, now you can't take a jurisdictional challenge. That's not so.
That see, we will decide on the issue of. We'll tell you. Only two issues we think is emerge for consideration.
Very
For one, which both of you have argued, what they see, class 1 will apply or class 19.
Yes.
Class 9 apply, automatically 52 apply.
All right, very well. Very well.
Number 2, as we have said, if you are to hold in your favor,
Yes, ma'am.
class 19 also apply and therefore section 52.
Yes.
It will be very difficult for us to hold and therefore it attains sanctity and then there's no way that the arbitrator can go into the tariff actually fixed.
My lord,
I will tell you why.
all right, very well, my lord.
I'll tell you why, because
My lord, your
see,
lordship.
once
Yes.
see, the arbitrary jurisdiction is this. However, once it goes before an independent authority, then it is not with respect to the challenge of notification or on the power of the government to ratify your decision, your resolution. But this is with respect to proper tariff to be fixed.
My lord, I bow down to that.
Yes.
Now that cannot be done by a private body. Arbitrator is a private body. He cannot.
All right. Got it.
Yeah, all right. Very well, your lordship has that. Now, my lord, only one subsidiary to this. My learned friend, my lord, has read out the award on this. What is the award saying? In 1993, your
Now we'll ask you.
yes,
Did you take any plea before the arbitrator?
yes.
That he has got no jurisdiction in the event of the arbitrator holding.
Yes.
That it is unilateral and the fixation is not correct. He does not have a jurisdiction to do so.
My lord, we did, my lord.
In which case
effectively.
only writ petition is the remedy.
Yes, yes, my lord, because
The
arbitration is going on the question.
you are a public authority.
Yes.
You have to see now. On the contrary, it is your case that the reasoning of the arbitrator with respect to fixation of the tariff having been fixed is not correct.
No.
Well,
That is not correct on the face of it. Just give me 1 minute on that.
What you are saying, irrelevant materials have been considered. You have not been given adequate opportunity.
No, I'm not saying all that.
And materials are not before.
My lord, let me just summarize in half a second. My lord, he says that I cannot fix a 1993 tariff because he's considering the reasonableness of a 1993 tariff because of something which has happened in 89. Now, my lord, this is a tariff fixation, a revision of an 85 tariff.
98 is.
No, my lord.
The-
89 first.
See,
He rejects 89.
one thing is to say
Yes.
that the reasoning of the arbitrator may not be correct. Number one.
I'm saying that also.
Number two, the arbitrator has not gone into the nitty-gritties. And number three, he may not be competent enough to fix going to the relative materials.
My lord, I have two submissions only, my lord.
Yes.
One is that he doesn't have the jurisdiction to question a notification.
Yes.
And the second thing is, my lord, his reasoning is utterly incorrect because he is fixing a revision of a 85 rate in 1993 and he says you can't look at 89, you can't look at 94. Yet, my lord, this will last for 10 years.
Internal mechanism.
So, my lord, what I'm saying is, my lord, he's revising a rate of 1985 for the next 10 years. And he says you can't look at 89, you can't look at 94. Then what will we look at? We have to find some material only for 93, for revising up to 2000.
You got it.
Yes, now.
No difficulty.
And my learned friend wishes to me to point out that at page 175, the ground has been taken.
9751.
Yes.
9751.
My lord, this is taken, my lord, in the appellate forum of before the appellate arbitration forum that the learned sole arbitrator has erred in declaring the notification to be bad in law. Page 175. I'll put it in the note, my lord, that we have taken that ground also.
Which one?
175 PPA, 175, 9751 is also.
In the first SLP, 975.
5 it is.
9751 is also.
The arbitration matter, my lord. Actually, 9751 is the arbitration.
Bottom.
Yes, bottom.
Yes.
Two.
Yes.
Now, so therefore, my lord, we'll put it down, my lord. Then, my lord,
What was the jurisdiction of the arbitrator then? If he could not go beyond the notification,
my lord, his jurisdiction.
rate he could have fixed them.
No, he was not supposed to fix rates if we are right. If they are right, then he will declare whatever is in the agreement is the correct rate.
No, agreement is old 85.
Maybe, my lord, but their contention always was that you can't change it.
Their contention is mutual consent. Because
Mutual consent, so you can't change it without mutual consent. Your lordship is right.
you had fixed it, some notification.
Yes,
Without mutual consent.
without mutual consent. And we have relied on 19 for that purpose.
You rely on 90.
Yes,
But the terms say mutual consent.
yes, one clause says.
What was the idea to send to arbitration if the arbitrator could not fix a rate beyond the notification?
See, you are trying to make the arbitrator like 34. See,
No.
you would appreciate.
No, my lord, suppose.
We'll tell you. You
Yes.
appreciate if your arguments are threefold.
Yes,
Number one, you can't touch the notification.
lordship.
Number two, the parameters they are taken into consideration for the for increasing tariffs.
Not for the
Not
arbiter. No.
for- you cannot do.
Correct.
Number three, even if it is not correct, let us assume the arbitrator fixes, then he should have taken into consideration of the relevant material.
Correct, my lord.
So now what you are trying to say is that only the first two.
No, I'm saying the third also, but
Third, because you are saying there's no jurisdiction barring. That's a problem.
no.
Already be considered, no problem.
We are, because the two sides took extreme views, my lord. They said without my agreement.
That is what we are trying to tell you.
You say unilateral.
See, it makes us also a bit difficult to appreciate if we have after applying our arbitrator. Anyway, we'll get
Very, very well, my lord.
yeah. Very well.
My lord, now, what is troubling your lordship is why go to the arbitrator at all? The answer is, my lord, we didn't go to the arbitrator, he filed a civil suit.
We got it.
Now, nobody can prevent him from filing a civil suit. Now,
Consent because at that time public sector was there, so all
yes,
this
that's all right, my
during
lord.
pendency it was.
See,
Correct? There was even an arbitration
See-
clause of some sort in the agreement.
I think to make some clarity, what we are saying is, arbitrator could have taken the role of the tariff authority earlier. That's what we are trying to tell you.
My lord,
That's what if he has other issue.
my lord, whether it can or not, I leave to your lordship.
Yes,
Very well.
Yeah, that's all.
Now, next thing is, my lord, as far as arbitration is
Especially
concerned.
when he refers one part there. If the remaining, but what does it mean? That only, all right.
Yes. Now, my lord, the second aspect is, as far as arbitration is concerned, is the question of limitation. There, my lord, there is enough authority that by giving one letter per year for 10 years, you cannot extend limitation. Representations, my lord, have never extended limitation. The Limitation Act will have to be taken into consideration. That's as far as the arbitration agreement part is concerned. Now I come to, my lord, the tariff authority part, the second writ petition, my lord. There, my lord, my learned friend, my lord, has taken your lordship through the orders as if there was a lot of discussion, there was a lot of application of mind. My argument is not application of mind. My argument is natural justice. And why? Now see the dates which he has put before your lordship. I gave your lordship the same dates, but not in the same order. I gave the 3 dates. My learned friend puts these dates in this fashion. First he says, interim order. I'm sorry, just 1 minute. Interim order on 29th of November 2010. Final order on 22nd of November 2011. And hearing granted on 9th December 2009. Now put it in the correct order. 2009, there was a presentation. One year after that,
Yes.
1 year after that, in 2010, an interim order is made.
No,
It-
where these dates are there, it's there in the award only.
that is
They are there in
in the list of dates.
Tariff order, these dates are there.
Yes.
What is there?
It is there, but I have given it in the list of dates.
No, let us see from the tariff order also.
Yes. Your lordship may see, the documents are also here. My learned friend read those documents.
We did
Page-
not note
page
that date.
39
239.
of 9870.
Yes. Yes, hearing was held on.
So, my lord, 9th of December 2009,
That was the only date.
is the date on which there was a presentation by the parties.
Yes.
Page 171 of
239 page in the second paper book it is there.
which SLP?
Second one it is there.
Yes. Now, anyway, my lord, there is no dispute.
Only hearing.
Only hearing. Hearing means presentation, PowerPoint. Now, the 29/11/2010 is an interim order.
Yes.
This interim order does not analyze. What it says is PPT's point of view, PPL's point of view. That's all it does. It has now collected the material which parties have filed and it has tabulated it. Then, my lord, it says that you give us more material.
So what was the interim award then?
There is no interim award. There's an interim order calling for more material.
Order only.
Yes, more material.
Amount was fixed.
No amount was fixed as such.
The methodology.
Yes, all right. He laid down the methodology. I cannot challenge, my lord, an interim award in that sense or an interim award in a separate proceeding. I have to wait for the final determination. Then what happens? He has laid down some methodology. Then he says, give me materials. Both sides have given materials. We are waiting for a hearing. 1 year after that, 29th of November 2011, 22nd of November 2011, without a hearing, after getting all the new material, after fixing prima facie the modality, he passes the final order. This is the problem. In that, between, my lord, 29 November 2010 and 22nd of November 2011, what he needed to do was to give us a chance to justify why we are asking for a particular rate. And, my lord, my respectful submission is that this is a very, very complicated hearing. It is really something which, my lord, I'll have great difficulty, my lord, in bringing before a court of law. So it is correct for them to give us a proper hearing as they do, my lord, in the Electricity Authority, in the Telecom Authority, etc., etc. That has not happened. Therefore, my lord, there is a number of points which never got decided, even though my learned friend says that there was a complete hearing.
We'll consider.
Now, just two more things.
Yes.
On the judgments, may I just take, my lord, 5 minutes of your lordship's time on judgment?
Some principles only are there.
Some of those principles are completely unexceptionable, no problem. I'll just point out my context. First of all, my lord, the Subodh judgment, the first one, is absolutely not applicable because Subodh is a cancellation of tender matter. A tender was floated, award was made, then cancelled by way of cancellation of tender. Court said no. Once you've given the award, it can only be cancelled in accordance with the contract. Now, my lord, this is an area of administrative law which is totally different from the two areas we are deciding. Your lordship is looking into now. One is arbitration and the other is, my lord, the tariff determination. So, Subodh, my lord, is not applicable or relevant at all. Secondly, my lord, when it comes to the other propositions, the propositions, my lord, I have no truck with. For instance, my lord, the proposition that a plausible view taken it should not be interfered with. The proposition that there has to be application of mind, etc., etc. We do not differ from that. Here, the proposition, as far as stamp is concerned, is not giving a hearing after the materials were all filed.
We have not.
Yes, and in the other case, it is that it is not applied the correct law. That's all. So therefore, my lord, non-application of mind is neither here nor there. That is not our case in either of these cases. So therefore, these judgments may not apply, my lord, is my respectful submission. I'll give, my lord, in detail all these, my lord, points in a written submission. Kindly give us till
Next Friday.
2 weeks. My learned friend wants 2 weeks, my lord. I leave it to your lordship. I said
77 পেজে আছে এটা এই পয়েন্টগুলো সব আছে
we are giving a written submission. There's nothing to prevent you from putting it there again.
भैया में क्या मुझको ससुर
Yes, so look. 16.
गुलिया में पहचान से
I have made the proposition. The judgments are all to be given along.
grateful.
My lord,
How much time you want?
No, whatever.
Weeks times? Or by next Friday?
Yes, I think.
by next Friday. Yes, next Friday.
We'll consider.
So, listen, boss,